Good morning, everyone, and welcome to LSU. We're so happy to have you here as we celebrate the 200th birthday of our 1825 Code and more than 300 years of civil law in Louisiana, a heritage that we hold proudly, a heritage that has withstood the test of time, and that testament to that is you being here. We're so honored to have you here. And let's travel back in time for this session. Let's go back to the early and very delicate years of our civil law heritage. Books were not easy to find. Law schools didn't exist back then. The whole bench and bar was different back then. And so the code itself was the foundational document. And I can't think of a better panel to walk us through those early, tender years of our heritage. Our first wonderful speaker is Ron Scalise, who comes to us from Tulane Law School, and he will talk to us about the 1825 Code, its didactic nature, and its enduring impact today. Ron, the floor is yours.
Thank you, Nick. Thank you, Nick. Thank you to Olivier for inviting me. Thank you to all of you for being here. Thanks to LSU and to all the sponsors of this wonderful event. And thanks, too, for giving me, I guess, pride of place as first. There's big shoes to fill. I told Olivier when I came in, it may start off bumpy, but you'll finish well tonight with the Tugger Lecture and Augustine Odette. What I'd like to talk to you about in my sort of 20 minutes is the didactic nature of the Louisiana Civil Code of 1825, and at least suggest to you why I think that is the case and why it's different than some of its predecessors. So, you've got a little preview of this already, but first, to give you a little bit of the history of the 1825 Code. Right? This is the legislative act that appoints the three drafters of the Civil Code. It's a big monumental task that these drafters have before them, but a very small piece of legislation. It's just 3 paragraphs. And in fact, there's only one really relevant first paragraph that tells the drafters what they are to do. It is they are to revise the law as they deem it advisable, by adding under each book and title and chapter of said work such laws as are in force or included therein and as need to be amended. The second paragraph really talks about the development of a commercial code. And then the third paragraph of this act sort of gives the drafters a $1,000 advance, kind of paltry amount, even perhaps for 1822, for all of their work. And then they're hastened to come back and report quickly. Right? At the first session of the legislature, they're supposed to make their sort of findings and report and present their work to the legislature. Here are the 3 individuals who were appointed: Pierre d'Herbigny, Edward Livingston, and Louis Moreau Lillet. They didn't complete their work in 1 year. So what they did is they issued a rather lengthy and informative preliminary report explaining to the legislature, we need more time. Right? Here's what we're doing. Here are the sources we're consulting, and we view the task as an important and significant one that we need a bit more time to work on. And so here you can see is some of the operative language from the preliminary report, because their task as they view it is a big one: to remedy the existing evil of being obliged in many cases to seek for our laws an undigested mass of ancient edicts and statutes, decisions, imperfectly recorded, and the contradictory opinions of jurists. In other words, they're taking a mass of complicated and inconsistent laws, and they're going to try to come up with a more perfect document that explains the law to the people. And then it goes on to highlight that the whole is rendered more obscure by the fact that a lot of these works are in a language that is inaccessible and can't be read. And of course, they're not talking about French at this point. They're talking about Spanish. Because the Louisiana Supreme Court had just recently issued their opinion in Cotton versus Cotton, telling the people and the lawyers of Louisiana that the 1808 Digest was great, but only to the extent that the provisions in the 1808 Digest are contradictory to prior law do they displace prior law. So in many instances, people seeking a resolution to their disputes would have to consult prior law to the 1808 Digest, which by and large was going to be in Spanish. So again, their task is a big one. And you can see what they tell us is here are the sources that we're going to look to. The laws of the Partidas, other statutes of Spain, right? So that, right off the bat, they tell you, our existing laws, stores of English jurisprudence, and the comprehensive codes of France that are so rich minds that they can sort of use to develop principles of law for Louisiana. So what are some of these sources? As I mentioned to you, first of all, the Digest of 1808 was the predecessor. That was Louisiana's first real attempt to codify the civil law. And of course, and I won't rehash it here, the debates about the sources of the 1808 Digest are legion. Here is just a small sampling of how those debates have played out in the law reviews over the years. Sort of ironically, a person with a Spanish surname, Rodolfo Batiza, arguing that the Civil Code is French, and someone, right, with a French name, Robert Pascal, arguing that it is Spanish. But that was the argument, right? And it's never been resolved to this day, and I'm not going to weigh in on it here, right? But this, again, is what the drafters had that they were moving and using to develop the 1825 Code from. And of course, there was the French Civil Code, which some would suggest was the basis of the 1808 Digest. And here, just a quick summary of what the French Civil Code at this time looks like. It's got 2,281 articles. It's broken up into 3 books, a very common and familiar style for us today. And here again is what the 1808 Digest looked like. 2,160 articles, so pretty close to the number of the French Civil Code, broken up in the same way. In French, so one might reasonably assume this was an influential document, but again, I'm not going to take a position on that at this point, right? What I'd like to talk to you about is the big break, the 1825 Code, which you can see is a substantial change from the 1808 Digest. Here we have 3,522 articles in this document, so it's 1.5 times the size of the Digest of 1808. There were 1,746 additions, 423 amendments, and 276 deletions from the 1808 Digest. So whatever they were doing, it was pretty significant, and it was a pretty big change from what they had done in the past. And again, the virtue of their preliminary report is they tell us what they were using to a large extent. Again, they're keeping a reverent eye on English common law, Spanish law, the French Civil Code, and Roman sources. But I want to flag for you that in the preliminary report, they take pains to point out the Napoleonic Code, which they suggest is not only a gift to the French Republic, but a gift of France to the entire world, right? And then they go on to highlight and to praise the nature of the French Civil Code and say it is, quote, nearer to perfection than any which preceded it, and evidently designed by the wonderful genius which planned and the learned jurists who executed this great work, etc., etc. So I take that as a pretty good signal that French law is going to be really important when we're developing and changing and writing the 1825 Civil Code. Yes, there's a whole bunch of sources that we're going to look to, but French law gets called out a number of times as a really important source that the drafters are going to go to. And I will highlight for you that, of course, there are important things that happened between the 1808 Digest and the 1825 Civil Code of Louisiana. First of all, France had had 21 years of experience now with their civil code, and people had begun writing not only treatises and teaching and trying to understand exactly what it is the French Civil Code means on a variety of provisions, how the provisions all relate to one another, and how they apply in modern society. So when our 1825 drafters are again looking for source material to use, they have now got 21 years of experience in France, which they didn't have. They only had 4 years at the time of the 1808 Digest, right? So one of the things that you will notice that takes, again, pride of place in the development of the 1825 Civil Code is a commentator named Tullier. Because Tullier had written his 16 volumes on the civil law of France in 1811. And of course, that's 3 years after the 1808 Digest and a significant number of years before the 18. So it's a new source for the drafters to look to in revising the 1825 Civil Code. And here are all the other treatises that we consider influential which didn't exist, right? Duranton doesn't come until 1841, Troplong until 42, Laurent until 69, Dumoulin until 74, and of course Aubry and Rowe until 97, right? So none of those are existing at this point. So what the drafters have at their disposal, the French Civil Code, the 1808 Digest, and Tullier. Not just Tullier, because of course they had relied upon other academic sources in the drafting of the 1808 Digest as well. So they're pre-codification writers that are also influential and important at the time of the 1825 Civil Code. Potier, right, is heavily relied upon in a number of areas, as is Domas. right, who had done these two important works that were used by our drafters. So why do I say the Civil Code of 1825 has a didactic nature? Everything I've told you so far has been kind of background for the pitch I'm about to make to you now. And the pitch I'm going to make to you now is using those sources, those writers, Toulier, Potier, Domat, right, and the French experience, help our drafters of the 1825 Code further explain the civil law of Louisiana in this new document. And in doing so, what they did is specifically write into Louisiana law things that didn't exist in the French Civil Code. And by that, I mean didactic matters that you wouldn't expect to find in a civil code, really, in any other places. So the Louisiana Civil Code is littered with examples, not rules of law that tell you how to resolve a particular dispute, but, oh, by the way, here's an example. That is something that's just didactic in nature, something that helps teach and educate, but something that doesn't resolve a particular dispute. So I'm just going to have an opportunity to give you a few examples of what I'm considering some examples in the Civil Code. So here is one, right? Predial servitudes. Predial servitudes, easements in the common law, things that have existed in Louisiana law for quite some time. Look at this Article 698. The following are examples of predial servitudes. Well, that's not resolving any disputes. It's just giving me a laundry list of different types of predial servitudes that exist. And then they go on to further explain in detail what a servitude of support is, what a servitude of view is, what a prohibition of view is, what a servitude of light is, none of which is solving any legal disputes. It's just teaching. It's didactic in nature. And the projet of the Civil Code of 1825 is kind of helpful in telling us, look, Louisiana law already permits every imaginable kind of servitude, but we think it'll be helpful to people to give them examples of the most common ones so they can understand it a bit better. And it's not just property, it's in obligations as well. So here is something that I and many others have criticized about Louisiana law, which has currently a definition of a, quote, real obligation, not something that exists in any other civil code that I am aware of. And in fact, the comments to our Article 1763 today acknowledge that. Right? The comments say, neither French civil law nor any modern civil code has established a classification like this one. We are isolated in the civil law world in having this concept in our code of a real obligation. And all it really is the flip side to a real right. Right? A right in a thing that is good against the world. Well, then, if you've got that right, some other person has an obligation to respect it. So not something that's terribly important, perhaps, and something that's probably a little inaccurate, but something that exists in modern law. It comes from the 1825 Civil Code. Here is the provision. When obligations are attached to real property, they form a third branch of this first division of obligations, which we call real obligations. So again, I'm critical of this concept. I don't love it. Writing on a blank slate, I'd probably get rid of it. But my point to you today is it comes from the 1825 Civil Code. Now, why is it there? It's there because the drafters of the projet in our Civil Code tell us. When we wrote this provision, we looked to quote writers. Now, they don't tell us which writers, right? It's not in the French Civil Code, it's not in any other civil code, it's not in Spanish law, but they found this concept in writers. Well, I'll tell you, because I did look, it's not in Potier, but it is in Toulier, right? Toulier is the first person who comes up with the idea of a, quote, real obligation. And that's not only acknowledged by more modern French commentators, but Toulier seems to criticize Potier in saying, oh, he forgot about this concept and didn't do anything. So obviously what our drafters were doing in 1825 was borrowing from academic commentary to write into obligations law now an example of something that they thought as helpful, that doesn't solve any disputes, but helps teach and explain the law to people. So those are my first pitch to you as to how the Civil Code is didactic. The second way I want to explain to you about how it's didactic, it teaches, doesn't solve disputes all the time, is our Civil Code also has lots of definitions, something you wouldn't expect to find in a civil code, something that is generally eschewed by civil codes in general, because that's up to the job of commentators to write and explain things that are definitional, right? They exist to a minimal extent in the French Civil Code, but again, not in the Louisiana Civil Code. Here's a really important one. The very definition of ownership, which we have in Article 477 in our Civil Code, comes from Article 480. of the 1825 Code. Ownership is a right by which a thing belongs to someone in particular to the exclusion of other persons. And again, the drafters tell us we got this concept from Potier, and we think it is helpful, they explain, to delineate that ownership is a right to the exclusion of others, right? So more sort of definitions, examples, didactic materials. Similarly, in the obligations context, right? Strictly personal inheritable obligations. We have definitions of those in our obligations articles. Again, things that don't solve disputes, but just explain. A strictly personal obligation is an obligation that dies with the obligor, whereas a heritable one can be passed on to his or her successors. That doesn't exist in French law. The French Civil Code just treats that as a matter of successions law. But we decided to write an example, to write an explanation, to put a definition in the obligation section, sort of delineating what a strictly personal obligation is and what a heritable obligation is. Again, I don't want to belabor this, but anybody who sort of teaches obligations in the state of Louisiana knows, well, when we explain contract law, the first provisions of contract law in the Louisiana Civil Code is this litany of definitions. Contracts can be onerous or gratuitous, bilateral or unilateral, commutative, independent, principal, accessory, and their definitions of all of those. Again, this comes straight from the 1825 Civil Code, where they are giving us definitions and examples of these different types of contracts. Not solving any disputes, just teaching us about what these things are and what they mean. And again, the drafters of the Civil Code in the projet tell us that's basically what they're doing. Yeah, there were some definitions in the 1808 Digest, but we didn't think those were particularly good, and so we improved them and rewrote them and made them more robust in the 1825 draft. And just to sort of end with my sort of litany of definitions, it's not just property, it's not just obligations. Here's the definition of a mortgage. A mortgage is a right granted by a creditor over property of the debtor for security of his debt. Comes straight from the 1825 Civil Code. The drafters tell us, we think it's helpful to explain what this means. The other explanation in the 1808 Digest was not terribly accurate. All right. And then to end, right, my examples, because I know I'm running short on time, is anybody, again, who has picked up the Louisiana Civil Code and thumbed through it knows we not only have examples sprinkled throughout, not only have definitions sprinkled throughout, but the very last article of the Civil Code, 3506, right, in the sort of book 3, is an article on definitions. That is, it's a litany, a long laundry list of terms that we define, which of course is unlike other civil codes. So here, again, from the 1825 Code, an abbreviated version, there are 32 different definitions. In the modern Louisiana Civil Code, they're kind of a handful. We've repealed a lot. But in 1825, there were 32 different terms that were defined, including the masculine gender comprehends the two sexes, right? Telling us how to read the Civil Code, in fact. Now, you'll be happy again, as I mentioned, the modern Civil Code doesn't have 32, it's only got a handful. The 1825 Civil Code did have 32 defined terms, but the projet to the code suggested they wanted 86 different terms defined, right? So at least by the initial draft and the final document, the number of definitions got cut back by about 50. But the idea that it's teaching us by explaining terms and giving us examples, I think, remains nonetheless. All right, I don't want to suggest to you it's just the 1825 Civil Code that is didactic. The 1808 Digest had a bit of that as well. Not quite as much as the 1825 Civil Code, but certainly some. In fact, the very first part of the Louisiana Civil Code is a preliminary title. And that preliminary title, as you can see, defines things like law and custom and tells us how to use the Civil Code. When matters, right, are governed by the sort of same issue or apply to the same issue, right, the law should be consistent. That is, reading things in pari materia. A roadmap, not giving us, not resolving any disputes, but teaching us how to use the Civil Code. Again, in the 1808 Digest, right, I love this provision where we're told you can sell a hope. That is, you can certainly sell a watch, you can sell a car, you can sell a tract of land, but you can even sell a chance, a hope. And as an example, from the 1808 Digest, they tell us a fisher can sell the haul of his net, right? Now that's a kind of didactic example that they give us to help explain it, but not resolve it. That comes from the digest. Here it is, Pomponius, right, talking about you can sell a chance, such as fish or birds which are yet to be caught. So the 1808 digest had a kind of didactic nature to it as well. One of my favorite examples talking about the price for a sale, again, going all the way back to Roman law, right? When you sell something, the price has got to be cantum, certain, verum, true, in pecunia numerata, in money, right? And later on it had to be just justum. Well, that's here in the Civil Code, right? It is, the price has got to be certain. The price has got to be serious, such that there is true agreement. And then look, it goes on to talk about a just price. That is, something ought not be out of all proportion, the price, to the value of the thing. Thus, the sale of a plantation for $1 is not a sale, but it may be a donation in disguise. So again, giving us examples to help explain and teach us how to apply the various provisions of the Civil Code. France had a little bit of this too, right? I don't want to pick just on Louisiana in this didactic nature. So here again, one of my sort of old favorite articles talking about you can't really gamble. Gambling contracts are not going to be enforceable. But things that involve skill, such as an exercise of the gun, foot, horse, or chariot racing. Never really been a big thing here in Louisiana, chariot racing. But that comes from the French Civil Code, as you can see, right? So there's even maybe a little bit of the didactic nature of the French Civil Code that we're borrowing in 1808. All right, so here's the payoff to the whole presentation, I promise, right? Which is why? Why is it between 1808 and 1825 that our drafters decided, well, we need our Civil Code not only to regulate relations among private people, but we need our Civil Code to teach the people of Louisiana, to explain the civil law. The reason that's the case, and I can't be sure, is because, as is already pointed out, there were no law schools in the state of Louisiana in 1825. The oldest law school in Louisiana is Tulane. It's the 12th oldest law school in the country. It wasn't established until 1847. LSU, where we are here, 1906, Loyola 1914, and Southern 1947. So there were no law schools for lawyers or people to be educated or trained in the Civil Code. So the Civil Code had to do some of that for them. And it's not just Louisiana. In fact, there's only really one law school in the entire United States in 1825, and it's Harvard in 1817. Penn State, 1834, Yale, 1843, Albany, 1851, and Columbia, 1858. So my point in telling you this is if you were a lawyer in Louisiana in 1825, you didn't become a lawyer by going to a Louisiana law school or a law school, period, right? How is it, then, that you got your training as a lawyer? Well, again, in addition to Harvard, there was this little Litchfield Law School, which was not really a law school, right? It was a judge who held lectures, right? And, you took sort of exams at the end of the week where you basically recited what you had been told. Even in 1891, some almost 70 years after the 1825 digest, only 20% of the practicing lawyers in the United States had graduated from law school, right? So they were learning the law through a mechanism other than formal training in school. The ABA didn't require graduation from law school as a condition to practice law until 1921. Lawyers in the 1800s, certainly here in Louisiana, became lawyers by the apprenticeship method, right? They sort of worked with existing lawyers, and this had been true since colonial times, oftentimes doing errands, copying documents, going to court with the lawyers, and observing how things were done, not a formal education. That is to be contrasted with France. So France had law schools going back to 1150. Right? The Faculty of Laws at Paris, and then Montpellier in 1249, Orleans in 1306, Poitiers in 1431. Now, I know what you're saying. Yeah, but they weren't studying civil law like we think of it back then. They were studying customary law and Roman law and really canon law in these areas, and that's true. But don't forget, in 1808, Napoleon creates 12 law faculties where French law and the Civil Code are going to be studied. So France has got a formal education system for law and doesn't need the level of didactic or teaching nature of the Civil Code that Louisiana certainly did. Not in 1808 and certainly not in 1825. Here again is what Louisiana looks like in 1825. population of the entire state was 153,000 people. The city of New Orleans had only 27,000 residents. No other city in 1820 was large enough to report on the actual numbers. The entire parish of East Baton Rouge, as late as 1840, only had roughly 2,000 people in it, right? Most of the lawyers in Louisiana, and it's only 565 people who are practicing law in Louisiana by 1839. 60% of those lawyers were Americans. And they were predominantly from, as you can see, Virginia, New York, Pennsylvania, Massachusetts, and Maryland. I tell you this because what this means, and what this suggests to me, is people practicing law in Louisiana in the early 1800s had learned to practice law through the apprenticeship system and learned to practice law through the apprenticeship system in a place other than Louisiana. So when we're adopting a civil code or revising the civil code of 1825, we need to explain to people what the civil law is, how it applies, what these terms mean. We need to be more didactic and more teaching in regard to these concepts than other civil codes might have to be. Because other civil law jurisdictions are going to have universities where civil law is studied. They're not using the apprenticeship system. And certainly the people who are learning the law are learning it from people who know how to practice that civil law. That is not the case in Louisiana. Louisiana was, in fact, a burgeoning legal market at this time. As you can see by comparison, in 1840, Massachusetts had only 640 lawyers in it, whereas Louisiana at the same time has got 565. That's not bad, right, for a relatively new state at the time. And then to end, right, what I'll suggest to you is studies have been done examining probate records when lawyers die. That is, when you die, let's make a list of everything you own, right, and give it to the court. Well, people have looked at these descriptions, these lists of assets of lawyers, and they tended not to have civil law sources in their libraries, right? As you can see, even lawyers as important as people like Livingston and Moreau-Lillet, yeah, their inventories for their successions list over 1,000 different books in many different languages. But that's not the case for the ordinary lawyer. The ordinary, I'm not sure what happened to the slide. The ordinary country lawyer, right, has just over 100 books in his library when he dies. Few, if any, of them are civil law sources, and to the extent they are civil law, it's people like Potier and Domas, that is pre-codification writers. So I end kind of where I started, which is the 1825 Civil Code has a didactic kind of quality to it. It's meant to teach, it's meant to educate, right? And that's a necessary thing because we didn't have any other way of explaining the civil law in Louisiana at that time. So the code had to take on that job. And I, for one, am thankful that it did because it has helped preserve, I think, the civil law in Louisiana to this day. Thank you very much.
Just a suggestion and an observation and a question. Well, the suggestion, it might be, maybe Delvin Cook could be influential because he was one of the first exegetical writers and he published his course in 1813. And he was quite influential elsewhere, especially in Europe and in Latin America. So maybe there's some kind of influence there. The second thing is that the French Civil Code also had quite a lot of definitions because the aspiration of the Codifier Commission was to make it accessible to the layman, which is really a fantasy, but still, the idea was to make such a didactic code that anyone could read it. Well, this starts with Leibniz and his influence on Domat, but that's a different kind of chapter. In fact, one of the definitions you pointed out, the definition of property in the Louisiana Civil Code, seems to come quite close with the definition of the Code Napoleon, 348, if I recall correctly. Curiously enough, the drafters point to Potier, but Potier defines property in a different manner. He quotes two different definitions. One belongs to Sassius and the other one to Bartolo Saxoferrato. And none of them seem to fit in the model of the Louisiana Civil Code. So this was kind of wow. a very wow moment. And curiously enough, there's also another definition that tends to fit into the definition of property. This is the definition given by the Siete Partidas. I'm quoting by heart, so so let me a little license. I think it's Partida 3rd, Title 28, Law 1, that says, señorío es el poder que ha en una cosa, todo hombre en una cosa de hacer de ella e en ella lo que quisiere, según Dios, según fuero. That's something like, property is the right to, that any man has over a thing to do with it and in it, well, different, whatever he likes, according to God and law. So it tends to fit, I think, those two might be the main influences. One last thing, just last. The final definitions, including this mention of gender, this all comes from the digest, straight from the digest. One of the last titles of book 50 of the digest, that's digest 5016, it's the definizione. So it's a long list of definitions that the legislator seems to have copied. It's so cool. So,
So thank you very much for, oh, I'm sorry. Do I need this? Oh, sorry. Thank you very much for those insightful comments. You're certainly right. The French Civil Code does have examples and it does have definitions. Had I had more time, I would have gone into some of those as well, because you're right, I agree, the French Civil Code has a didactic nature as well. I think the Louisiana Civil Code takes it to the next level with those. I'll have to look more at the ownership articles. That's something I wasn't aware of, but I'll dig into that more.
I'll send you an article I wrote.
That would be great, that'd be great. Similarly with the definitions article at the end, interestingly enough, the drafters do not identify the digest as the source of those definitions in the projet. But I'll have to compare the digest definitions to the ones in both the projet and in the 1825 Civil Code to see just how many terms we stole from the Romans. So thank you for that. Michael.
I have a question very quickly. And what's your position? How do you stand on the fabrique of the code, of the way the code should be made? What's your position?
On how it should be made?
Yeah.
Yeah.
This has to teach us. This
Sure.
is a teaching lesson.
Yeah.
So should a code be didactic so that citizens can read it and understand? Or should a code be spare so that only law students and lawyers can understand? What's your position?
Yeah, so good question. I'll cop out by saying somewhere in the middle, perhaps, right? Which is, I think, a little bit of the didactic nature is fine. But for the time and the purpose that the 1825 Civil Code had, I understand why it was drafted the way it was. And I'm supportive of that. I think in the modern day, we could probably cleave out some of that. It's probably not necessary anymore. And in fact, we've really done that over the course of time. So Article 3506, as I mentioned, now has a handful of definitions as opposed to 32 different ones, right? Because we've gradually realized we really don't need those articles anymore. And I might like to see a little more of that in the modern day, but certainly I'm glad the drafters did what they did in 1825.
I have a quick question. I find it very frustrating to find out what books they were using. So if you look at Mitchell Franklin's article, I think from 1940, on the Library of Moreau-Lillet and the Library of Edward Livingston, it's extremely frustrating. It will just say Dumas. Or even worse, it'll just say for Livingston, Loi Civile. Which book? So you really, we don't really know what they did with the sources. That's one thing. Unless maybe someone knows the answer to that question. What did they, we don't have Livingston's copy with, this is stupid, I love this, or whatever. There's no, you don't have that. I think the effect of cherry-picking sources, if that's the right word, being eclectic with the sources that they used, might have the same effect that Tribonian did with Roman law when all the Roman law was cut up into little pieces and thrown into pigeonholes. We sort of lose track of the entire the book that we're culling something from. And finally, about whether there could be a lay code, a lay civil code. It's hard enough to teach law to law students using a civil code.
Yeah.
I don't know if I need mine. We're recording, so. Oh, okay. Thank you. That would be the last question.
Yeah, I certainly don't need a mic, George, but I've been instructed to stand here.
Okay, well, thank you. Thank you very much. That was brilliant. Thank you. I don't want to put what I'm about to mention on the same level as the Louisiana Civil Code, but as you were describing its purposes and its methodology, I really couldn't help but think at least a little bit about restatements of the law in the United States, the purpose of which was, among other things, to make the law more coherent, to reconcile differences, which is what you said was driving the drafters, at least to some extent. And curiously, the restatements have illustrations. They literally have examples scattered throughout. I'm using the word you used, scattered. I don't know if the Louisiana Civil Code was any kind of an inspiration. I suppose that's unlikely. But the affinities are really striking, I would say.
I completely agree with that. When I teach first-year law students and explain to them what a restatement is, I kind of compare it to the closest thing in the U.S. to a civil code. I think it's much more civil code-like than something like the UCC, to be honest, is. The illustrations you're pointing out in the restatement are absolutely there. Those are usually in what we would consider the comments to the civil code article. So it's not in the black letter law, right? They'll then have revision comments, and then they'll have illustration section. But you're right, they do give examples. Their purpose certainly is to teach, and the provisions of the restatement are often drafted in a kind of lay, easy-to-read style, right? And then they leave to the illustrations and the comments all the details and the nitty-gritty. But I think it's very civil code-like as well. So I agree with you.
Thank you. Thank you.
Thank you.
Thank you so much, Ron. You did a wonderful job as always. And Ron just set the scene for us of how the Civil Code is didactic. The Civil Code also was an opportunity for meaningful reform in some areas of the law. And our great comparativist, my good friend John Cairns, will talk to us about how the 1825 Civil Code reformed guardianship, a very interesting area of the law. John, thank you.
It's a great pleasure to be here, and thanks to Olivia for organizing this wonderful conference. I'm going to introduce my topic in a self-indulgent way by saying that I spent the summer of 1981 in LSU in the Center of Civil Law Studies, enjoying the support and kindness of late Saul Litvinoff, Alan Lavesseur, and Richard Kilburn, among many others who were very kind to me. And I was working on a revision of my PhD thesis for publication, and I never wanted to rush. My lightly revised PhD thesis was published in 2015, so I tend to go slowly with things. But during that visit, I became interested in the question of minority and guardianship in the colonial, territorial, and early state period. And excited by the source material to which I had access, on my return to Belfast, where I then taught, I produced a 6-chapter manuscript on this, tracing the law from 1712 to 1830. I worked on this off and on for a while, and the late Joe McKnight, whom I also first met in Baton Rouge in that summer, thought I needed to do further research in the archives, and he was undoubtedly correct. I used the various sources I used and things like this. So this is kind of incomplete work, which, as I look at my age, I shall probably never complete. However, there we are. But my main concern was similar to that in my thesis, namely to explore the sources drawn on by the legislators and the redactors, and to try to understand why they chose the provisions they did in drawing up their codes. In both studies, my focus was on the first book of the code, whether the 1808 Digest or the Code of 1825 that we celebrate today. Now, for someone enthused by Alan Watson's theories of legal transplants, the first book of the Louisiana Code, or the Louisiana Codes, is particularly fascinating. because it was the book that varied most from the primary models of the codes, which were the Code Civil and the Projet de l'An 8. And all had a first book devoted to persons, but as I've argued elsewhere, the Digest and the successor code of 1825 had an approach rather different from that of the French code to persons. And the Digest the Digest of Orleans, that is, preserved a more traditional focus on persons than that was carried out in the French Code Civil. The French Code Civil has a lot of stuff on état civil and things like this in its first book. Now, in 1904, Joseph Drake of the University of Michigan wrote that the Civil Code of Louisiana, and I quote, "though Spanish in substance, is in fact confessedly French in form." For this, he relied on a paper published by former Chief Justice Edwin T. Merrick in 1871. Chief Justice of Louisiana, I mean, that is. And I'll quote Chief Justice Merrick. He said, "Whenever they found an article in the Projet of the French Code," he didn't realize they had access to the 1804 code, if ever they found an article in the Projet of the French Code which fully expressed the sense and meaning of a provision of the law of Louisiana, it was appropriated. In other instances, the French text was amended to conform to our law and so adopted. In others, the Spanish law was first written in French and translated into English. Nevertheless, the laws of Louisiana, who are different from the Napoleonic Code, have been preserved, and thus the Civil Code contains some provisions in sharp contrast with the Napoleon Code. Now, Merrick is working here with a simple syllogism. The law in Louisiana after the acquisition was Spanish ultramarine law, ultimately, with a default provision to the law of Castile. And he says the redactors were instructed in 1808 to codify the civil laws in force, ergo, the code is Spanish. Now, this, of course, is completely wrong. It's just a false syllogism, and it reflects, I think, very much the time when Merrick was writing, where it's a type of high legislative positivism, it's the move towards codification in Germany. It's a very, very different world to the world of 1808, and it does not reflect any kind of reality. Now, what is interesting, though, is that the codifiers of the Digest and the Code of 1825 acted very freely. That's the thing that I find very interesting about what they do. I could say that the issue of guardianship of minors might give some kind of support to Merrick's view, because the Digest in the Code of 1808, the Digest Code of 1825, followed the Castilian law in dividing minority into pupillage and minority, or non-age into pupillage and minority, in a way similar to Roman law, and indeed to my own home law of Scotland until 1986. The Code Civil des Français had a unitary concept of guardianship, following the general practice of the Pays de droit coutumier. The system of pupillage and minority was to be found, however, in the Pays de droit écrit in southern France, and as well as in Castile. Although I should say both of these could differ from the Roman law. They're all different, but they had that kind of basic structure. Now, if this similarity in pupillage and minority to the Castilian law is what is most obvious initially, when you look at the law, it is in fact pretty superficial, I think. And in the period between 1808 and 1830, saw its progressive erosion until its final abolition in the latter year by the legislature. And I'm going to address two topics, one, that erosion, and also the issue of language, which clearly caused a lot of problems in discussing guardianship. I'll make a few assertions about guardianship in general, just to set up what I'm going to say. First of all, in 1808, the Castilian concept of paternal authority is abolished. It goes. Secondly, the Digest of 1808 created 4 types of tutorship, more than in the codes of than Castilian law, I may say. It created natural tutorship, which derives from the French code, what it calls natural tutorship, so the term is not used there. Dative tutorship, legitimate and testamentary tutorship. Natural tutorship goes to a surviving spouse when the marriage ends. Thus, a father would be a natural tutor and subject to all the requisites of tutorship once his wife died. Okay. He could not continue to administer his children's property as paterfamilias, but as a tutor. The institution of the family meeting was reintroduced. This is an institution of northern France. It had been operative in Louisiana before the change of the laws, and it disappears under the Spanish regime, but it's reintroduced in 1808, and also they introduced the office of under-tutor, subrogé-tuteur. One could go on, but all of this is quite contrary to the Castilian law on guardianship, and it's rooted in the practices of northern France. I'm not going to go into the details, so it's the details that make this very interesting, I have to say, but no, there's the possibility of doing that. But it's obvious that the redactors, they're not simply reintroducing French law, they're not just simply copying, they are doing something creative, and that's what I think is very interesting about the codifications in Louisiana. They were innovating. Now, there's a good general account of the development of the law, actually, by Harry Sachs in the Louisiana Law Review of 1956, excuse me, and more recently, Monica Hoff-Wallace has given short account of the Spanish and French backgrounds of contemporary Louisiana law and tutorship. But what happens is there's obviously a complex interaction with the texts on the part of the people producing the legislation and the codes. And I think that that shows a desire to have greater protection of children in a variety of ways, and there are all kinds of nuances that suggest this. And it's evident, for example, that they give much greater authority to the judge in terms of guardianship than, say, the French Code does in 1808 and carried on in 1825. Right, I'll turn to the issue of languages. Producing a code in 2 languages creates problems, as I'm sure we can all realize. One can be differences introduced by typesetting, quite interested in books and books, structural things, interested in typesetting. One of the articles, for example, in the digest, the English text of Article 54 on page 68 states that the inventory of the minor's property should be made in the presence of the under-tutor. This requirement, found in the Ancien Droit of Northern France, is omitted in the French text, but found in the English text. And I am quite convinced it's a typesetting error by the French typesetter. It's just been omitted. And interestingly enough, in the Code of 1825, the English language article has this, is amended to conform to the French one rather than the other way around, which is what one should have been, I thought. Now, as today is the Journée Internationale de la Francophonie, I'm here to explain briefly the problems that arose from finding a technical language. Now, both the digest and the code have preserved the division into pupillage and minority, in a technical sense. And it's a Roman division. But the French models they are working with, as foundation in 1808 and carrying on in 1825, presuppose unitary minority. And it's just minority, either mineur and minority. There's not a division in the French texts of the Code Civil. Now, they should have found a language. It would have been perfectly easy to find a language to do this because you can find French texts on this in all the laws of southern France before the Code. You could find English language versions of this if you looked at Scots law, although I suspect they didn't, and they didn't have access to judging by the libraries that have just been referred to. I have not noticed anything Scottish, but so they probably don't have access to that. But in theory, it existed. Now, for clarity, it was generally necessary to use the term pupil or pupille, and pupillarity or pupillarité, and to restrict the terms minor and minority to those over the legal ages of puberty, 12 for young women and 14 for young men. And the usage of the Pété droit écrit is very clear in this. So it exists. It's very possible to have done that. But of course, the Code Civil and the Projet de l'an 8 just use the term minorité for anyone under the age of 21, from birth to 21. It's minorité. And tutelle for the guardianship. No tutelle, no curatelle. Now, the digest, followed by the Code of 1825, had a title on the distinction of persons, which was largely copied from Doma. The chapter on the distinction of persons, established by law, ended with 2 articles. Sorry, I misread that. The chapter on the distinction of persons, established by law, to be a bit clearer, ended with 2 articles. The first stated that males under 14 and females under 12 are called impuberes, they're using the Latin term, impubères in the French article. Those above those ages are called adults, adultes. This is copied from Doma quite straight away. The next article states that minors of both sexes are those who have not yet attained the age of 21. And it says, until that age, they are rested under the direction of a tutor or curator. When they attain that age, they are of full age. Okay, 21. Now, the English text is of full age or majors. Words are mysteriously omitted in the 1825 Code, or majors. I'm not sure why. Now, that's the title equivalent to the title of the Code Civil des mineurs, de la tutelle et de l'émancipation. Simply insert curatelle after tutelle. In this it has other small changes in the title of the title, so to speak. The discussion of those subject to tutorship and curatorship, in general, simply refers to those people as mineurs, whether they're below or above the legal ages of puberty. And it does distinguish between tutors and curators in the traditional kind of way. And occasionally you find insertion of the term mineur pubère or mineur impubère, but by and large they just use the general French term mineur. And of course, this permitted them very easy adoption and drafting of texts of the Code Civil and its projet. At one level, it was all clear in law. You know, if you were a lawyer and you're used to handling the material, you could see how this worked. But there are still potential problems. For example, if you come to the articles on contractual capacity, the redactors of the 1808 Code, they simply follow the Code Civil des Français. Contractual capacity, it's there. Now, thus they provide an article saying that minors are incapable of contracting. This is not accurate for mineurs pubères, who are capable of contracting, potentially with the assistance of a curator. And so there are little problems like that cropped up. Now, this section of the code on contracting was proposed for radical revision in the Projet of 1823, and this was followed through in the Code of 1825. Its Article 1778, based on the Projet of 1823, regulated the issue of contracts by minors. According to the late Rodolfo Batizza, who we've seen mentioned already, the text was taken from Putty, and he's undoubtedly correct. Putty, of course, just talks of minors and tutors in the single system of tutorship of northern France. There's a nod in the digest to the double system by the addition of or curator and or curators. The revision states emancipated minors, quote, may contract in the cases already provided by law, and when not emancipated, their contracts are valid if made with intervention of their tutors and curators with the assent of a family meeting in the cases whereby law is required. But you see, it's fudging the distinction. It says it may be in the circumstances allied, and just it links them together, tutors and curators. Now, and the terminological mix did cause confusion. This becomes clear from the case of Bernard contre Vigneault in 1820, which concerned a suit by children against those who had managed their property after the death of their mother. The complexity of the facts I won't bother with you with, but I'll just quote what counsel for the children commented. And I quote, we observe that the irregularities of the words tutor and curator of the minor and major children, etc., which are to be found in the notarial deed, cannot prejudice the plaintiffs who are not parties to it. And they're not to suffer from the connivance of the parties or from the ignorance of the notary. But the nature of the thing shows by itself that by the word minor, the notary meant the minors under the age of puberty, and by the word major, those above that age. So you can see there is a problem coming through here. And I'm going to cut this a bit shorter now. And there are some changes on title of Curatel in 1825 made on the recommendations of the Projet. And I'll just come to two that I think are significant. Article 363 of the new code was a new provision, providing that until the minor had made a choice of curator, the functions of the tutor continue in the same manner as if the minor had not reached the age of puberty. Okay, so if he or she does make a choice, tutelle continues, just as if they were mineurs impubères. Okay. The tutorship just continues. In 1828, an act of the state legislature reinforced the trend identifiable in this 363 article by saying that when a father or mother has appointed a tutor by will, the child was to remain under that tutor until emancipation or the age of majority. So again, tutelle was to continue. You're not going to become a minor with a curator in the older sense. And it also further provided that a minor who is under the authority of his father or mother, as is of course permitted, should remain under their authority until he reaches the age of majority. So if your tutor was one of your parents, you'd never left tutorship. Okay, that's what they're saying. And in 1830, of course, it's just finally completely abolished. And suddenly, it's like the Northern French law. There's a unitary system of minority. Now, one of the interesting effects of this, the fact that they hadn't really worked out a better terminology in the codes, meant that that was easy to do. You just got rid of it because already the articles, most of the articles were prepared for that, because most of the articles presupposed a unitary minority. And you can see this with the annotated codes of 1838 and 1853 with the adjustments made there or the recommendations. So it was easily done. So I'll just finish there. Thank you.
Thank you so much, John. Any questions for parents?
Thank you very much. Thank you very much, John. When you were describing the process, I was trying to imagine how was this happening? How were they sitting around a table? Some of them were practicing lawyers, others were at different points, members of the bar or the bench.
Yeah.
And what was that? What do you think? And this is guessing, unless you came across, maybe you're guessing,
Yeah.
but that might help us build a context. What is that triggered these changes, these decisions? Can you try to imagine what that could be? Thank you.
I can only think the trigger, you can only work out the trigger from reading the decisions, I think, because we don't have really records. There's what is said in the projet for 1823, but they say very little, in fact. And also, you have to remember that when people write in things like projet or advance, they're not always telling the truth, you know. they're kind of documents for public consumption. So I can speculate, and in my unpublished 6-chapter manuscript, I do a lot of speculation, but it's, I think they are, well, one of the things you notice, the Louisiana territorial and then the state legislature issues a lot of private acts of parliament, of acts of the legislature, giving minors full rights of majority. It does this quite often. They're quite common, as you can see through the legislation. So I wonder, one can speculate, is there some issue here about adulthood, minority, and what's going on in Louisiana economically? Also, they're very, very worried about there are lots and lots of changes in the legislation about how minors' property is to be looked after. Is it all to be sold? Are they to generate a certain proportion of income and all this kind of stuff? And they changed that all through from 1808 to 1825 and after. It's just forever changing that kind of regime of how minors' property is to be managed. Now, so what the redactors are doing, I think they're working on some kind of implicit assumption of what is good, or what they think is good, what is efficient for young people and just for young people, and what is efficient in the circumstances of the territory. One thing that's a problem is that the appointment of tutors and curators goes through the Court of Probates in Louisiana, and its records are closed. So it's maybe unknowable, but so it may be something to do with the court, the way the court operated. But I think they're just trying to make, I'm benevolent towards them, I think they're trying to make up what they think is going to be a good system for the children, good for the parents, and good for the tutors. So tutorship's not too burdensome, the children are looked after, and their resources are protected. I think that's their kind of general aims. And I think they're sitting there with, they've got the Code of 1804, they've got a whole variety of sources, they've really got a lot of things around them, and they say, that looks good. It's what we might in Britain call a pick and mix kind of thing, of trying to put together something. And in putting things together in that way, you often end up with a bit of incoherence, as you can see, find certainly in the Digest of 1808. Yeah.
Yes, absolutely. Thank you, John. Because, for example, some of the studies that Rebecca Scott
Yeah.
tries to see what is it triggered. Yeah, thank you. What is it triggered the change in the letter of the law or in the decision of the court? And sometimes it's mentioned often that Louisiana was a very small community of lawyers.
Yeah.
Everybody knew each other.
Yeah, yeah.
It could be that maybe one actor had a very important stake on a minor that was growing in age, and maybe there was a land property or something. So maybe that's something you may want to look
Yeah, well,
into.
I mean, it could well be. I mean, this is the problem. It's a question of research. For example, I know that in the territorial period, there is a spectacular litigation involving a curator, in fact involving Hugh Laverne, the future notary of the de Laverne volume. His father and mother had fallen out. His father was clearly a bit nuts, and the family, they divorced, they'd separated. He was looked after by his maternal uncle, and they were suing his father. It's kind of an extraordinary thing. They're clearly applying Spanish law, of course. This is before 1808. And so I suspect some provisions have some reflection of that. And you can see, even just looking through Martin's reports, you might start to speculate about things. Or why in 1825 did they say stop requiring tutors to, or I can't remember, it's the 1825 one, but why did they stop requiring tutors to guarantee a certain 5% income to the miners from the property and things like this? Is that to do with the 1825 stock market crash in London? You know, I don't know. But because there's so little evidence, it's very difficult to go beyond what there is in the code. Now, it may be, if it were possible, it's not something I have the capacity, the possibility to do, to go delve through whatever archival material there is of lawyers in Louisiana that period. You might come up with something, but you might not. It's also the other thing. Okay, thank you.
Thank you so very much. And I remember that I forgot to make a very important announcement that's not entirely obvious. I'm not Andrea Carroll. She was supposed to chair our session today. She sends her regrets that she can't be with us and her regards, so I'm sitting in for her. So John and Ron did a wonderful job of showing us the foundational years of our civil code. David Rooney, my good friend from Loyola, will bring us back to today and talk to us about lessons learned from the 1825 code. David, the floor is yours.
Nick is at a disadvantage because I haven't shown him my draft, so he doesn't know what I'm going to talk about. I mean, not really. This is the book we are talking about. This is the projet, or 2/3 of this book is the projet. This is not a very usable or user-friendly book. If you hold it in your hands, you can hurt yourself because it's quite heavy and quite inconvenient. But more seriously, it is not through numbered. So you can't find out, you have to deduce where you are in the book unless you know exactly already where you are in the book. So it's not very usable, but I've been using it. So I entitled my remarks, getting here from there. I knew I was going to mess that up. Getting here from there. So we have today's civil code. That's what's here. And there is this thing, actually in enacted form, the Civil Code of 1825. But there is also what Yiannopoulos referred to as the great reservoir of the civil law. That's what's underneath the argument that was alluded to by Ron and avoided by Ron, I think quite wisely. The debate on the actual sources of the Civil Code of 1825, the actual sources of the Digest of 1808. So this is our past as lawyers, as professors. So I thought, well, how am I going to approach this topic, the topic of today's conference? And I thought, instead of trying to do something compendious as Ron did, or something also equally compendious that Professor Cairns did, like taking the whole thing. I'm retired. That's far too much to do. So I thought, let me pick something of interest that I can explain in, I knew it would be 20 minutes. So I discovered the following. I discovered a very odd chapter in the title on sale called compulsory transfer, expropriation forcée. I thought, what is this doing in here? So this is in chapter 11 of, is this okay? On sale, of the title on sale. Chapter 11, book 3, title 7. So what else is in there? All the stuff that you expect to be in is in there. Chapters 1 through 10, nothing surprising. Of the nature and form of the contract of sale, de la nature et de la forme du contrat de vente, chapter 1. Les personnes capables d'acheter, de vendre, chapter 2. How shocking. Chapter 3, what can be sold? Des choses qui peuvent être vendues. Chapter 4, comment le contrat de vente s'accomplit, how a sale is performed. Chapter 5, who bears the risk of the thing, favorite topic in the sales class, the risk of loss of the thing due to accident while the sale is in process. Le risque de la chose after the sale is completed. I'll come back to this risk idea because there's an interesting comment having to do with it that the redactors include. Chapter 6, the seller's obligations, les obligations de vendeur. In 3 sections, the first section, delivery, or tradition de la chose vendue. Second section, the seller's obligations, warranty against eviction of the buyer from the thing sold, la garantie en cas d'éviction de la chose vendue. And third section, rétribution, des vices de la chose qui donne lieu à l'action rédhibitoire. Now, there's another comment there that I'll come back to. Chapter 7, the buyer's obligations, pay the price. Les obligations de l'acheteur, nullity and rescission of the sale. Note that here the French text has not rescission or récision, has résolution, which we now use differently. De la nullité ou de la résolution de la vente. 2 sections in that chapter. Sale with the right of redemption, de la faculté de rémunérer, ou de rachat. Max Nathan has a very bad joke about that, which I'll share with you privately. You'll know why I do that. Second section, rescission for lesion beyond moiety, also a favorite topic in the sales course. Auctions, chapter 9, or public sales, des ventes à l'enchère, ou vente publique. Chapter 10, judicial sales. And chapter 12, giving in payment, de la dation en paiement, which in Louisiana English is a verb, to dash on something. I love that. We dash on stuff. So back to chapter 11. Why did I find this interesting? On the compulsory transfer of property, de l'expropriation forcée, the first, there's just 4 articles that do the work in this little section. Just 4 articles, and there's some procedural articles that follow. So the first draft article becomes Article 2604 of the Code of 1825, 2626 of the final 1870 Civil Code. The first law of society being, the article states, that the general interest shall be preferred to that of individuals. Every individual who possesses, under the protection of the laws, any particular property is tacitly subjected to the obligation of yielding it to the community whenever it becomes necessary for the general use. That's surprising, isn't it? La première loi there's not really much difference between the French and the English. La première loi des sociétés étant que l'intérêt commun, so general interest, intérêt commun, that's pretty close, soit toujours préféré à l'intérêt particulier, tout individu qui possède, sous la protection des lois, une propriété particulière, est tacitement soumis à l'obligation de la céder à la communauté dans le cas où elle deviendrait nécessaire à l'usage commun. That's an odd thing to find in a civil code. I'll come back. Well, there'll be lots to say about that, perhaps. I'm thinking about John Rawls. I'm thinking about political philosophy. What is this thing? The second draft article became Article 2605 of the 1825 Code. Si le propriétaire d'une chose devenue nécessaire à l'usage commun refuse de la céder ou on demande un prix exorbitant, il peut en être exproprié par autorité de la justice. If the proprietor of a thing necessary for the general use refuses to yield it or demands an exorbitant price, the property may be divested, expropriated from him by authority of law. The third article reads, il est dû, dans tous les cas, au propriétaire un juste prix de l'objet dont on exproprie. The English is, in all cases, a fair price should be given to the owner for the thing of which he is dispossessed. A fair price is not a particularly nuanced translation of juste prix, because juste prix recalls lots of other, the canon law, for example. The fourth draft article, the price ought to be paid to him before the expropriation, that is to say, before he has delivered the possession or it has been finally taken from him in case of resistance. Ce juste prix doit lui être payé avant l'expropriation, c'est-à-dire avant qu'il ait livré la possession ou qu'elle lui ait été ôtée par force s'il résiste. Okay, that's it. That's the heart of it. The other articles that follow are strictly procedural in nature, I would say. They deal with timing, choosing a jury who's going to name the just price in such cases, what the property is worth, la somme que vaut ce bien, and so on. So my reaction to this was with surprise and delight, since I knew I was going to say something today. Over time, the legislature will add rules and articles that complicate the procedure significantly. What happens after the enactment of the 1825 Code is that we move from an agricultural economy in Louisiana, where issues have to do mostly with drainage and whether someone can build a levee on your property to prevent someone else's property from flooding, that sort of thing, to much more typical industrial revolution type issues that come up in the subsequent years. So I'm not interested in that. We're just trying to figure out what happened in 1825. The articles remain in the Civil Code until basically 1985. During the sale revision, it is recommended, before I joined the Sales Revision Committee, I was put on that committee. I have a story about that too, also, which I will not share with you, about Litvinoff. Privately, I will, of course, if you are interested. Anyway, so in '85, these articles on expropriation come out of the code. They're just slated for demolition. Okay, where'd they come from? There's no corresponding article in the 1808 Digest or in the French Civil Code dealing with this particular problem. Now, de Baptiste, God bless him, finds a source in Domat for this rule. He gives it his abbreviation SI, substantially influenced, which means that we don't have to necessarily believe that he's right. So here's the text he cites. Il arrive assez souvent que les choses qui appartiennent à des particuliers se trouvent nécessaires pour quelque usage public, etc. Si dans ces cas, ils refusent de les vendre, ils y sont contraints par l'autorité de la justice, parce que toute chose étant faite pour l'usage de la société, avant qu'une passe à l'usage des particuliers, ils ne possèdent qu'à cette condition, que leur intérêt cédera à l'intérêt public dans les nécessités qui le demanderont. This comes from Domat, the Loi Civile, the new edition from 1777. Shall I translate off the cuff? It happens often, rather often, that things that belong to individuals become necessary or are found necessary for some public use. And if in these cases the individuals refuse to sell them, they are bound by the authority of justice, because all things being created or being made for the use of society, before anyone goes to the use of individuals, particulier, they only possess it under that condition, that their interest will give way to the public interest in the necessities that will demand it. So my translation off the cuff is not verbatim, perhaps good enough. So a lot is left out of the Civil Code of 1825 that was in the source. I think that Batista is correct in naming that as potential influence on the text that we're reading. All right. Now, references are made a few times already to comments made in the enactment, Ron in particular, comments made during the redaction of the Civil Code of 1825. Fewer comments about the Civil Code of, the Digest of 1808. The drafters provided no motive for why they inserted this article in the code. It really does not belong where it is. What's the inspiration? We just don't know. I think this is one of those things where we have to say, we just don't know, and probably will never know. In comparison, we find the drafters much more forthcoming, the drafters of the 1825 Civil Code, much more forthcoming in providing comments on the sale articles. For example, in Redhibition, Chapter 6, Section 3, for the risk to the thing following sale, the projet provides this chapter, although it seems to be in a great measure a repetition of principles laid down under the title Conventional Obligations, appear to us indispensable. The matter treated here belongs more particularly to the title of sale and presents certain modifications of it which are only applicable to that species of contract. Okay. All right, let me... On Redhibition, the projet provides, this section is remolded entirely, and although the principles contained in it remain the same, and there are few additional provisions, yet we think that the matter is here presented with more order and clearness. So, if I had to guess, I would say those comments came from Livingston. This is something we've been not focusing on. In the Civil Code of 1825, the work was not divided equally. And exactly what each of the three laborers was doing is not entirely clear. Moreau Lillet worked on, I'm pretty sure, books 1 and 2. Livingston on book 3. And D'Orbigny was really working on procedure. He was actually working on the code of practice, if I'm not incorrect. So the work was not divided equally, and we'd be surprised to think that they were working closely together. In the famous case of Cotin versus Cotin, which is one of the triggers for the Civil Code of 1825, that revives the Spanish sources and creates a problem for the civil law in Louisiana, Livingston was for the plaintiff. Moreau Lillet for the defendant, and D'Urbigny was the judge who writes the opinion. It's a small society. Everybody knew each other. I don't want to say they were finding themselves work. I would be tempted myself. The sum of money that was mentioned, $1,000, that was just the first installment. They were well paid. The salary of the governor was, I think, $5,000 or $6,000. They were paid between $2,000 and $3,000 for their work as jurisconsults on the 1825 Civil Code. So it was interesting work, as we used to say in practice. Now, Nicholas is being very kind. He's not pushing me along. I think my favorite comment that appears in the Civil Code, in the draft Civil Code, that monster that I've got on the floor there, is I've got two comments. One is, cette disposition n'a pas besoin de commentaire. This disposition needs no comment. Well, why are you writing that? Or immediately following, this is actually from in Article 18, Book 1, Title 3, Chapter 4, page 7, in case you're keeping track. Same page. The utility of these additional dispositions need not be explained. L'utilité de ces dispositions additionnelles n'a pas besoin d'être démontrée. So, we have a sort of odd man out in Louisiana civil law history, this little chapter in the title on sale. I think that we should pause for a second on the role of notaries at the time in shaping family transactions. And I think that's just where I'm going to quite abruptly leave the result of my remarks, and I'll look forward to your questions. Thank you.
Professor Gruening, I think it seemed, if I judge correctly, that it's a mystery as to when this disappeared from our code, and I presume it disappeared from the code because of the Fifth Amendment. Do you think that we would be better with the original from the 1825 code that included a jury to judge what the proper price would be than we are under the takings clause, in which the same municipality that's taking gets to determine what the price will be?
Well, I feel very good. My former student has asked a very interesting question, and which means I probably can't answer it. During the sales revision, under the direction of Professor Litvinoff, the articles that I just went over were removed without comment. Before I joined the committee in '87, they came out in 1985. And I never had a chance to talk to Saul about them, to ask him why they left. I'm sure he would have something interesting to say, but I don't know the answer. You mentioned the role of the jury in fixing the value of the property. It doesn't seem at all inappropriate, either in Louisiana or anywhere else for that matter, because it's a takings problem. It's a takings problem. Does that get anywhere near an answer to be an answer to your question? Okay, good. She was equally dissatisfied in class as well.
Well, thank you, Professor Gruening. This has been really interesting, extremely interesting, I must say. I might have an inkling of where these dispositions might have come from. Because, you know, in the seventh novel of the Corpus Juris Civilis. Seventh novel, chapter 2, paragraph 11, you got a disposition on expropriation made by Justinian. It's a constitution of Justinian of the 535 that also has a kind of a similar wording. Siqua communis commoditas et utilitatem rei publica respiciens causa et possessione exigiam. So it does sound a bit like the justification. And this novel was also received in the Siete Partidas, at least in two places. One is Partida 3, title 18.
Sorry, what number, please?
Partida 3, third book, title 18, Law 31, and in Partida 2, title 1, Law 2. So maybe I know it's a long shot, but it might have had some influence.
The difficulty is that the most interesting language, to me at any rate, in that first article doesn't appear in the source that's cited. At least not the source that's, that Professor Baptista cited. It's close, but no cigar. So it really, I think we're just not, we may never know exactly what they were looking at.
Dean Algaro?
Yes. Professor Gruding, good to see you. I don't come at this from another source specifically, but it's interesting to me to think historically what had happened. So from 1803 to 1825, the United States has gotten this land that has the Mississippi River, that has Native Americans who have land. And I wonder if there are sources from the United States where we have people coming in saying, wait, we want some of this valuable property, we need it. And so I wonder if there are United States or English sources for it, and it came from a need, like a need for the government to want to be able to take over this property.
To expropriate it.
Correct.
I'm not aware, I don't see exactly what I can do with your question. So I don't think that was the inspiration behind the articles in the code. We should recall, one of the things we haven't mentioned is that the transfer from territory to statehood was a conservative move because the property was in private hands already, and the idea was not to disturb the ownership of the property that was there, that the ownership was in place. I'm not getting a clear response out of my brain here. So I think that they were more concerned with taking land in order to build levees, to build drainage, to construct drainage and that sort of thing, than they would have been, say, with the exploitation of property for the cultivation of cotton or sugar. Sugar was being cultivated at the time, but it was not, I don't think, the title to the land was not, I don't think was a problem as such, particularly. There were problems within families, family disputes over who owned what. That was a very bad answer, I apologize.
Thank you so much. And last but certainly not least, Professor Michael McCauley from our sister jurisdiction of Quebec, who will talk to us about civil codes as expressions of social projects. Professor McCauley.
Thank you, Nick, for introducing me. Many of you know me, and many of you know my thoughts on a wide variety of subjects. I beg to report that any position I held in the past when I was teaching here and then teaching elsewhere has anchored itself more firmly in my mind. And I cannot be moved from positions I've always held, but have now more firm. The first thing I want to sort of ask is, why are we here? What is the purpose of an anniversary, a codal birthday? What do we do with it apart from having good meals and meeting friends? Does it mean anything to us as jurists today and for the future? In 2004, Alain Levasseur, who was at that time heading the Association Henri Capiton, 2004 at the Law Center, Alain organized a colloquium and to celebrate the 200th anniversary of the French Code. And I made some remarks, short remarks. Everyone made short remarks at that particular conference or colloquium. And my thesis was that celebrating the birthday, the anniversary of a code is a mnemonic device. It is something that allows us to develop a memory of what was in a certain book, why the book is manufactured that way, why the book is celebrated and not forgotten. And that is, I think, why we're here today, is to develop that memory, but a memory that will serve us today, a memory of the good things of the 1825 Code that will serve us today and lead us into the future. So, let me begin. The Louisiana Civil Code of 1825 and its underscoring codification process, just an aside, when I taught here I said codification, and then I went back to codification when I left. But its underscoring codification process, they are really sort of what I call hapax phenomena. They are phenomena that occur only once. The specificity of a particular code for a particular people at a particular time, redacted on the basis of a particular imagination of the law as a singular event and a unique phenomenon. Thus, in some important way, all codes are incommensurable. It's nonetheless fun to study them and to comment on them. So perhaps then, we can talk about codes by asking the following. Is there a meta-discourse that can capture codification and deliver it up to us as a discrete object? A thing to be known, and known completely, is an understanding of codification and exercise in theory, a matter of knowledge, a speculative venture. Is codification a tool that promotes mere memorization of specific rules, or something more? These broad queries can be broken down into a simplified series of unsimple questions, the first of which is, what is codification? The second of which is, what is the true telos of codification? What is its end game? Is it more than just organized noise? On the topic of the first question, code watchers and fans of codification in the civil law of the West, by the way, where is the West, idealize codification. They trumpet the process and method of codification. Codification and its product, civil code, is the systematic and rational expression of the law. It is characterized by simplicity, plain redaction, certainty, justice, modernity, and comprehensiveness. Codification promotes continuity of the legal tradition. It fosters stability. It has a grammar and an architecture. All of this you know, right? In sum, and as Denis de Béchillon in his essay L'imaginaire d'un code would have it, the code contains the law in a single finite space and prevents it from exploding. The assembly of rules in a finite space provides a type of internal armor or orthopedic structure, he says, which prevents the fragmented body of rules from bursting out. As a result, Bichon continues to propound, there is a clear demarcation between un dedans, the inside of a code, and un dehors, an outside of a code. There is no interstitial space. In his over-the-top assessment of the merits of the revised Civil Code of Louisiana, Henry Plouche Dart had this to say in 1925. The Civil Code of Louisiana has been properly called the most perfect child of the civil law. Indeed, if we could separate ourselves from the past and regard the book with the eyes of a new race coming fresh upon its discovery, we would declare, as our ancestors declared of another code, that it is one of the wonderful products of the human mind. Yet a civil code is surely more than the sum of all these attributes that I have listed. A civil code, in the civil law tradition, should have a set of fundamental beliefs and core guidelines, core principles. It should subscribe to a particular ideology and foster a certain social project. That is to say, a roadmap which guides the actions of civil society. As a social project, a civil code must be an initiative aimed at improving the well-being of citizens and addressing social issues through actions of solidarity and community. Accordingly, a civil code should have a well-articulated vision, a vision which is not necessarily immutable, but which at least has a strong perfume of permanence. In my view, and this is my thesis, the Louisiana Civil Codes of 1825 and 1870 have a social project admirable then, and arguably, in many respects, admirable today. These codes are strongly ideological. They are systems of enforceable rules governing social relations, and are ideological because they are systems which are inextricably intertwined with political ideas. That is to say, ideas generated by the lived experience of citizens. Brian Young, in his assessment of the politics of codification with reference to the 1866 Civil Code of Lower Canada, states that there was a profound ideological shift in Lower Canadian society that gave priority to exchange and individual property rights. This ideological shift gave rise to Quebec's 1866 codification, says Young. What then prompted Louisiana's 1825 codification? What is the great political ideological movement? Well, the February 1823 preliminary report of Code Commissioners we have discussed this morning reports as follows: by these means, our code, although imperfect at first, will be progressing towards perfection. It will be so formed that every future amendment may be inserted under its proper head, so as not to spoil the integrity of the whole. Every judicial decision will throw light on its excellencies or defects. In that report, the commissioners state that it was their duty to prepare all the rules we deem necessary for stating and defining the rights of individuals in their personal relations to each other. It was equally their duty, and in their words, the execution of our trust, to, as they say, remove the oppression, the reproach, the absurdity of being governed by laws of which a complete collection has never been seen in the state, written in languages which few understand, and so voluminous, so obscure, so contradictory, that human intellect, however enlarged, human life, however prolonged, would be insufficient to understand or even to peruse them. The English translation of the report, here as in, rather the French translation of the report, here as in some other places, is considered improved. But it's the English translation of what is arguably the French original that lends credence to Borges' remark, el original es infiel a la traducción. The original is unfaithful to the translation. It would therefore seem that simplification, coherence, comprehensiveness, the resulting production of a complete statement of rules for the proper conduct of citizens form one of the principal objectives of the codification process. Another important objective is the securing of happiness. A civil code vehiculates the idea that citizens deserve to be and to be made happy, and that happiness resides in ownership. These objectives can be attained by the promotion of cooperation. And yet there's more, and yet is there no more? Was there not some overarching social project, some ideological roadmap that spurred on the legislature and commissioners? Something more than legal coherence and universal happiness. We say that the 1825 and 1870 civil codes promoted the family, and accordingly, that they were structurally familial. I do not think that the social project of these codes can be reduced to this simple statement. Then what was it? Perhaps the ideology underscoring these codes, its meta-discourse, is inchoate. Perhaps the social project and ideological roadmap of the 1825 and 1870 civil codes is their promotion of cooperation among the Louisiana citizenry. Citizens were compelled to cooperate with each other. They were compelled to respect and cooperate with everyone for the spiritual and temporal good of all. This is the ontological moral obligation of all. I can hear a voice beyond the grave. His voice, the voice of Robert Anthony Pascal, telling us this and instructing us, or at least me, to hold true to this notion of cooperation. The ontological obligation is well evidenced by both the 1825 and 1870 civil codes throughout their books. Every institution of these codes promotes happiness and cooperation. The two concepts are intertwined. Consider the institutions of the private legal order, all of which secure ownership in their simple and coherent expression. Forced heirship, that is to say, compulsory distribution on death to descendants and sometimes others, collation, equalization of proportionate share of forced heirs, alimony on dissolution of marriage and alimony for children, prohibition of substitutions, ownership is for the living, prohibition of gifts omnium bonorum, that is to say, a prohibition to gift all or substantially all of one's property, alimentary pension, provision for one's descendants and ascendants during their lifetime, tutorship and curatorship, lesion, clawback of consideration paid in excess of true value, community property, equal sharing of matrimonial property, numerous clauses, the closed set of real rights, prohibition of pacts on a future succession, that is to say, agreements in advance regarding distribution on death, the marital portion, compensation to surviving spouse where deceased spouse dies rich in comparison, spousal usufruct in favor of the surviving spouse, probate, that is payment to a deceased creditors, executorship, testamentary freedom and capacity. intestate succession, present interests, ownership, usufruct, use, and habitation, prohibitions of alienation, and all of the good stuff. The law is complex, but the clear expression of these institutions, just listed, and their unwavering vocation to secure happiness are paradigmatic. In my paper, I intend to study these institutions in fine and contrast them with the current state of the law in the modern codes of Louisiana and Quebec. The current state of the law demonstrates that we have abandoned the roadmap of Louisiana's 19th century codes. By doing so, we have jettisoned their social projects and have cast aside our ontological moral obligation. Thank you very much.
Thank you so much for your presentation. I have a question with respect to the Lower Canadian Civil Code. You've mentioned the book by Brian Young, in which he reports a great ideological shift in the 1866 Civil Code. But his book is written from a very strong Marxist perspective. For him, the Civil Code is pretty much a capitalist affair. It enshrined the free circulation of property, freedom of contract, women as traders, etc., etc. However, in Quebec, we also have a nationalist school of law that emerged in 1920s, 1950s, that says that the purpose, the objective of the Civil Code was to preserve the Francophone culture and the language of the law and the language of the population. So it expressed the Volksgeist of Quebec population, etc., etc. So what is your take on this? So would you agree that Civil Code is an economic affair which reflects politics and economics, or is it more a cultural thing that in case of Francophone jurisdictions in larger states like Quebec and Louisiana is for preservation of the language, of the Francophone identity, of local customs and beliefs? So what do you think on this?
I think for the 19th century codification process, in many jurisdictions, the idea of freedom of contract, freedom of most commercial transactions, the marketplace, that was the economic focus of society at the time, of politics at the time, that prompted the codification to take on a certain style. And I do think you're correct that things have changed, that in this, we take for granted, I think we take for granted, that market forces are still important. I mean, even in our comparative law books, unlike René David's book, no one talks about the socialist or communist tradition of law, or not anymore within the Western world. So I think, you know, the reasons, the rationale for new codes or revised codes or recodification changes from one century to another. In the Quebec case, however, I do not think that there was a school of thought that the Civil Code should act as a way of preserving the French culture and the French language. This idea, the Civil Code is in both languages, but this idea is very recent, that all of the legislative efforts in Quebec must secure the happiness of the French language and the local culture. But I do endorse the idea that what prompts revision, new codification, recodification, does differ from time to time, and that Brian Young's book has a certain Marxist perspective. He teaches at a Marxist university, at which I attend some courses, because they're free for old people. So, yeah, so thank you for that comment.
Yeah, thanks, Michael, for your presentation. It was very interesting, made me think. So you use the expression, the ideology of the codes, yes, which is a very well-known expression from, at least from Merriman, John Henry Merriman. He used the ideology of the Civil Code. So, and you said that the code can be explained for it's a particular text for a particular people in a particular time. But when you talk about the ideology of the code as a social project, it seems to me perhaps it was applicable to any code. And my question is, what do you think is the peculiar ideology of the Louisiana Civil Codes distinguishable from other modern codes?
I think it is as I explain in my written paper, it is the proliferation of all of these institutions of the law. For example, the Louisiana Civil Code does contain, it's altered now, this provision for a marital, as it were, compensatory allowance, that where one spouse dies, rich in comparison to another, then there should be some mechanism to make up that difference. And that is from Spanish law. And I do think that unlike, for example, the Quebec Code, the Louisiana codes do have obviously forced heirship, which is different now than it used to be. Quebec never had forced heirship in the modern era. It has lesion. Quebec, for example, does not have lesion among adults, not really, except in sort of consumer contracts. So it was if you think of the institutions, you should tell me in the private law what the Louisiana Code does not address. That is an important issue. And I think and what I like about it is that it looks at all parts of private law that people are likely to encounter in their daily lives. So that, I think, is what makes it a bit different, because it's really buttressed. It's very strong in the 19th century on how society should look and how people should interact with each other.
So, Michael, thank you very much for your interesting presentation. Since we're here talking about the 1825 codification, I guess my question is somewhat unfair. That is, it's going to ask you a little bit about the 1808 Digest and the modern 1976 continuous revision of the Civil Code. You mentioned both the 1825 and the 1870 codes in particular as being social projects. Obviously, for reasons you discussed, the 1825 code's got forced heirship, lesion, community property, and the 1870 code was obviously done after the Civil War and removed the vestiges of slavery. So my question is, you didn't mention the 1808 Digest. Do you think that is also a social project that fits within your rubric? Because a lot of those institutions you identified, lesion, forced heirship, are all there as well, with possible exception, I guess.
I do, and they are in the French Code, and they're all products of the Enlightenment. They're all products of the general early 19th century, Napoleonic abandonment of feudalism, promotion of individuality. So yes, I do think the Digest was the beginning. Right. It's really, that's why memory, I think, is important. We have everywhere.
But you hinted at the end that you think we've abandoned that now.
I think,
but a lot of those institutions that you've identified connected with happiness are still there. Forced heirship looks different, to be sure.
They're there in some form, right? I mean, they're there, and forced heirship in Louisiana now is not what it used to be. The marital portion, I think it's $1 million. I don't know if it's indexed for inflation. Community property has changed. I mean, the law has become, in the code, has abandoned simplicity. It's so complicated. And then in the ancillaries, et cetera. So I think that, we're abandoning not only how codes are made, how we think about codes, but we're also abandoning the institutions that bound people together, and I think, that's one of the interesting things we hear on the news. We care for our family, we care for our children, and our children are the most important thing in our lives. And then we now don't endorse that in our statutory law, but we march against it. We, in our statutory law, in the code, say, well, they're grabby, they're greedy, and so they're no longer going to be forced heirs except in certain circumstances. So, yeah, that's, I think, it's just the beginning of the end, I think. And also the extra-codal law is so strong now that the civil code is sort of annoying. It must be annoying when the standard edition costs $500 for people who don't come from $500 last year from Louisiana. The standard edition of the civil code, I mean, in 2 volumes with comments, very nicely produced. When I was here 20 years ago, it cost $90. I used to ask West Publishing to give me 3 copies, 1 to mark up, 1 to keep, and then 1 to give away to someone. But no, $500, and what I like about it is I discovered that West Publishing offers an installment plan that you can buy the Louisiana Civil Code on installments, $500. Now, of course, there is a student code, but that's interesting. There is a student code produced here at LSU, which costs, I don't know, maybe $50 or $60 or $70, but I mean, that in a way speaks volumes for how
Don't forget the insightful editor's notes.
Yeah. So that is, that's like the abandonment. That is the abandonment, I think, of the 19th century ideology. And you just can't get the code, right? You can't get the code, and if you get it, it's on a computer, and then you have to scroll up and down, which is precisely the way code should not be read. And so we're becoming a bit like Haiti under Duvalier, which had the civil code, not one copy of which could be found at that time. I think we did.
Thank you very much. Thank you so much, Michael. Thank you to all our wonderful panelists. We're going to take a 30-minute break before we get to our next panel. Please enjoy coffee and fellowship. Thank you again for being with us today.